Today we shall discuss about the importance of investigation in criminal justicing system. The term investigation in a criminal proceeding denotes all the proceedings laid down in a code of criminal procedure which is meant for collecting evidence and which is to be conducted by a police officer or by any person who is authorized by a magistrate for that purpose. The importance of investigation in criminal justicing system requires a deep appreciation, as without investigation or proper investigation, criminal justicing system will fail and feeble. The aim of criminal justicing system is to punish wrongdoers in order to set an example for the future. For this purpose, there is a hierarchy of the criminal courts that are established, and criminal law is administered in accordance with the procedure, and the result is either an acquittal or a conviction. If there be any order of conviction, then a sentence hearing will follow and punishment may be imposed. In appropriate cases, the accused is released after admonition or on probation. A criminal administration of justice requires a chain of acts, that is, an information of commission of offence given or received by the police, apprehending the accused person or persons, collection of evidence by the police from the persons who are acquainted with the facts of the case, preparation of a charge sheet by the prosecution department and submit the same to the trial court, commencement of the trial by the court by following the enacted procedure, framing a charge against the accused if he claims to be tried, the finding of the court that may be conviction or acquittal, and hearing in the sentence that may be passed against the accused and serving the sentence by the accused person. The task of investigation by the police to collect evidence is very onerous for the reason that without evidence the court is helpless to administer justice. There exists some conventional maxims of administering criminal justice which assume the civilized norms of this land and have been followed. To mention some of such maxims are: first, justice should not only be done, but should manifestly shown to have been done. Secondly, the prosecution must prove the allegation against the accused beyond reasonable doubt. If there is any doubt in the prosecution story against the accused, then benefit of doubt is given to the accused. Thirdly, the maxim goes like this: it is better to acquit 100 criminals than to convict an innocent person. Besides these maxims, reference may also be made to the Universal Declaration of the Human Rights 1948, which declared in Article 11 that everyone charged with a penal offence has the right to be presumed innocent until proved guilty by the law in a public trial. In order to appreciate the importance of investigation in criminal justicing system, it is imperative to refer to the procedural laws of the land to find out the system of investigation is enacted in legal provisions. In India, the Indian Penal Code 1860 has made provisions for General Penal Code for India and contains numerous substantive provisions of offences and punishments. The code lays down provisions of punishments, general exceptions, and various acts or omissions which are punishable under the code. The function of a court of justice is to ascertain the existence of or non-existence of certain facts and to apply the substantive law to the ascertained facts. In a criminal trial, the object is to ascertain the liability to punishment of the accused person. And here comes the necessity of criminal procedure code and a law of evidence, the means whereby a court informs itself of the existence of facts is called evidence. Here comes the role of the investigating agency. Unless the facts be correctly ascertained, however accurate the application of the substantive law might be, the result cannot be free from error. The importance of investigation comes into play in order to ascertain the facts correctly. The present law on criminal procedure is the Code of Criminal Procedure 1973. The Act was passed in order to consolidate and amend the law relating to criminal procedure. Section 4 of the Code provides that all offences under the Indian Penal Code 1860 shall be investigated, inquired into, tried, and otherwise dealt with according to the provisions laid down in the Code. Chapter 12 of the Code incorporates the provisions of informations to the police and their powers to investigation. Investigation connotes the proceedings under the Code of Criminal Procedure for collection of evidence by the police. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try. A proceeding of a police officer at any such case and at any stage shall not be called in question on the ground that the case was one which such officer was not empowered to investigate. Any magistrate empowered to take cognizance of offence under section 190 of the Code may also order such an investigation. Section 157 of the Code lays down the procedure for investigation. This section casts a duty upon the investigating officer to forthwith send the report of the cognizable offence to the concerned magistrate. The purpose of sending the report forthwith to the concerned magistrate is to keep the concerned magistrate informed of the investigation of a cognizable offence, so that he may be able to control the investigation and, if required, to issue appropriate directions. Such magistrate, on receiving such report, may direct an investigation or, if he thinks fit, at once proceed or depute any magistrate subordinate to him to proceed to hold a preliminary inquiry into or otherwise to dispose of the case in the manner provided under the Code. Section 161 of the Code of Criminal Procedure lays down the provisions of examination of witnesses by the police, which is popularly known as 161 evidence. Any officer making an investigation or any police officer not below the rank as the state government may prescribe may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than the questions, the answers to which would expose him to a criminal charge or to a penalty or forfeiture. The investigating officer shall record separately of the statement of each person whose statements he records. The statements made under this section may also be recorded by audio, video, electronic means, provided that the statement of a woman against whom the offences of outraging modesty of a woman, eve-teasing, voyeurism, stalking, attempt to disrobe her, or rape is alleged to have committed or attempted shall be recorded by a woman police officer. While taking this 161 evidence, a police officer shall not use any inducement, threat, or promise to extract information, where during the stage when an offence of committing rape or attempt to commit rape is under investigation, the victim of rape shall be examined by a registered medical practitioner and with the consent of the woman, and that too within 24 hours from the time of receiving the information relating to the commission of such offence. Whenever an officer in charge of a police station or the police officer making the investigation has reasonable grounds for believing that anything is necessary for the purpose of investigation into any offence which he is authorized to investigate, may be found in any place within the limits of the police station of which he is in charge or to which he is attached, and such thing, in his opinion, cannot be obtained without undue delay. Such officer may, after recording in writing the grounds of his belief and specifying the thing for which the search is to be made, for such thing in any place within the limits of such station, carry out the search without having a search warrant issued by a magistrate. However, copies of the record prepared while making the search shall forthwith be sent to the nearest magistrate empowered to take cognizance of the offence, and also the owner and the occupier of the place searched when application is made to furnish the copies of the records. In case an officer in charge or a police officer not below the rank of sub-inspector making an investigation may require an officer in charge of another police station to allow search to be made in any place within the limits of the other police station. In the course of investigation, no police officers shall detain in custody a person arrested without warrant for a longer period than 24 hours except by an order of a magistrate under section 167 of the Code. Section 167 lays down the procedure when investigation cannot be completed within the period of 24 hours. This is not only a legal provision under the Code of Criminal Procedure, but there exists guaranteed fundamental rights in this regard in the Constitution of India. Under Article 22, Clause 2 of the Constitution, every person who is arrested and detained in custody shall be produced before the nearest magistrate within the period of 24 hours of such arrest, excluding the time necessary for journey from the place of the arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. The Code of Criminal Procedure incorporated this constitutional guarantee by making provision at section 57. If the police officer cannot complete the investigation within a period of 24 hours as fixed by section 57 of Code, and there appear reasonable grounds for believing that the accusation is well founded, the police officer making the investigation shall transmit to the nearest judicial magistrate a copy of the entries in the case diary relating to the case and shall forward the accused to such magistrate. The magistrate to whom the accused person is forwarded may authorize detention of the accused in such custody as the magistrate may think fit, not exceeding 15 days in whole. If any question arises whether an accused person was produced before the magistrate as required under the law, the production may be proved by the signature of the accused on the order authorizing detention. If in any case triable by a magistrate is a summons case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offence unless the police officer making the investigation satisfies the magistrate that in the interest of justice, continuation of the investigation beyond a period of 6 months is necessary. When any order stopping further investigation into an offence has been made by a magistrate, the sessions judge may, if he is satisfied on the application made to him or otherwise that further investigation into the offence ought to be made, may vacate the order and direct further investigation into the offence. When any subordinate police officer has made any investigation, he shall report the result of such investigation to the officer in charge of the police station. If upon an investigation it appears to the officer in charge of a police station that there is no sufficient evidence or reasonable ground for suspicion to justify the forwarding of the accused to a magistrate, such person may be released by the police on executing a bond with or without surety. Thereafter, the cases are to be sent to magistrate when evidence is sufficient. Every police officer making an investigation shall day by day enter his proceedings in the investigation in a diary stating time at which the information reached him, the time which he began and closed his investigation, the place and places visited by him, and statements of the circumstances as ascertained through his investigation. The 161 statements recorded during the course of investigation shall also be inserted in the case diary. The Code of Criminal Procedure mandates that every investigation shall be completed without unnecessary delay. Section 173 of the Code lays down that investigation in relation to rape of a child may be completed within 3 months from the date on which the information was recorded by the officer in charge of the police station. As soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report, which is called a charge sheet. The charge sheet shall contain the names of the parties, nature of the information, names of the persons who appear to be acquainted with the circumstances of the case, whether any offence appears to have committed, and if so, by whom, whether the accused has been arrested, whether he has been released on bond, and if so, whether with or without sureties, whether he has been forwarded to the custody under Section 170, whether the report of the medical examination of the woman has been attached where the investigation relates to an offence under Section 376E of the Indian Penal Code. The officer shall also communicate the action taken by him to the person, if any, by whom the information relating to the commission of the offence was first given. When such report in respect of the case, when the evidence is sufficient, the officer in charge of the case shall forward to the magistrate along with the report all documents or relevant extracts thereof on which the prosecution proposes to rely other than those already sent to the magistrate during the investigation, and the 161 evidence of all persons whom the prosecution proposes to examine as its witnesses. A further investigation is not precluded even after submission of charge sheet to the magistrate if the officer in charge of the police station obtains further evidence, oral or documentary. The police officer shall forward the further report to the magistrate regarding the evidence. The police report, that is the result of the investigation under Chapter 12 of the Code of Criminal Procedure, is a conclusion that an investigating officer draws on the basis of the materials collected during the investigation. Such conclusion can only form the basis of the competent court to take cognizance of the offence and to proceed with the case for trial. The court is to commence the trial and the prosecution is to prove the case against the accused beyond reasonable doubt. The court cannot rely solely on the investigation by the police or the result thereof. To convict or acquit a person, the prosecution is to establish the case against the accused by producing witnesses whose statements are taken by the police and by using the materials collected by the police during the investigation. When the officer in charge of a police station receives information that a person has committed suicide or has been killed by another or by an animal or by machinery or by an accident or died in the circumstances raising reasonable suspicion that some other person has committed an offence, he shall immediately give intimation thereof to the nearest executive magistrate, namely a district magistrate or subdivisional magistrate or any other executive magistrate specially empowered, and the police officer shall proceed to the place where the body of such deceased person is. He shall make investigation in presence of 2 or more respectable inhabitants of the neighborhood. He shall draw up a report of the apparent cause of death, describing such wounds, fractures, bruises, and other marks of injury as may be found on the body, and stating in what manner and by what weapon or instrument, if any, such marks appear to have been inflicted. The report shall be signed by such police officer and other persons, or by so many of them as concur therein, and shall be forthwith forwarded to the district magistrate or subdivisional magistrate. In certain cases is when the case involves suicide by a woman within 7 years of her marriage. The case relates to the death of a woman within 7 years of her marriage in any circumstances relating to reasonable suspicion that some other person committed an offence in relation to such woman. The case relates to death of a woman within 7 years of the marriage, and any relative of the woman has made a request. There is any doubt regarding the cause of death. The police officer, for any other reason, consider it expedient to do so. Such police officer shall forward the body with a view to its being examined to the nearest civil surgeon or other qualified medical man appointed in this behalf by the state government. This step shall be taken if the state of the weather and the distance admit of its being so forwarded without the risk of such putrefaction on the road as would render such examination useless. A police officer proceeding under this provision may, by order in writing, summon 2 or more persons for the purpose of the said investigation, and any other person who appears to be acquainted with the facts of the case. Every person so summoned shall be bound to attend and answer truly all questions. If the facts do not disclose a cognizable offence, such persons shall not be required by the police officer to attend a magistrate court. The importance of investigation in criminal justicing system can be seen as above. In administration of criminal justice, it is a sort of relay race which originates from the motion of the police machinery. The court is to wait till the arrival of the investigation report. This will bridge the gap between the investigation, collection of evidence, and the commencement of the proceedings of the court in pursuance of the investigation so collected. The investigation is deficient, then the benefit goes to the accused person. So friends, we conclude here for today. Thank you very much.